And who better than our own, the Honorable Justice Peggy Quince, to discuss that topic with us. Before we get to her presentation, however, I'd like to do a little bit of Zoom etiquette with you. Because we want to make sure that this is a pleasant experience for everybody on board, we want to ask you to do two things at this time. We're going to ask you, if you haven't already, to mute your mic, and also to turn off your video so that we preserve bandwidth so everybody can hear and see the Honorable Justice Quince as she presents. We will be recording this program this morning. So for those of you that would like to review it, or if you have friends that were not able to participate, they will be able to find it on our YouTube station. So we also will be taking questions at the end. If you'd like to type your question into the chat box, Mary Ann will be going through those questions at the end of Justice Quince's program. So we thank you for being with us. And with that, I'm going to turn it over to Mary Ann. Thanks, Mary Ann, for organizing this.
Thank you, and thank you to Justice Quince. I'd like to take a couple of minutes to go through her biography, because I think it's essential to understanding the value of the perspective she's bringing to us this morning. Retired Justice Peggy Ann Quince was born in Norfolk, Virginia, second of 5 children. The Justice and her siblings grew up in the segregated South. After completion of undergraduate and law school, Justice Quince married fellow law student, the late Fred Buckine, and they have 2 daughters, Peggy Laverne and Laura Laverne. Justice Quince earned a BS degree in zoology from Howard University in 1970, then followed with a JD from the Catholic University of America in 1975. She is also the recipient of honorary Doctor of Laws degrees from Stetson University, St. Thomas University, and Nova Southeastern School of Law. The Justice began her legal career in Washington, D.C. as a hearing officer, but moved back home to Norfolk to enter into private practice with an emphasis in real property and domestic relations. A year later, the Justice relocated to Florida and started a practice in Bradenton, Florida, 1978, and focused her skills in civil law. In 1980, Justice Quince began her 13-year tenure in the criminal division of the Florida Attorney General's office. She served as the Tampa bureau chief for 5 years and handled death penalty direct appeals and post-conviction matters exclusively for 3 years. As an assistant attorney general, she handled numerous appeals to the Florida 2nd District Court of Appeal and the Florida Supreme Court, the Federal 11th Circuit Court of Appeals, and the United States Supreme Court. In 1993, Justice Peggy Quince became the first African-American female to be appointed to one of the district courts of appeals when she was appointed by the late Governor Lawton Chiles to the 2nd District Court of Appeals. 5 years later, Justice Quince had the distinct privilege of being jointly appointed to the Florida Supreme Court by Governor Chiles and Governor-elect Jeb Bush. A third governor had input when Governor Chiles died, and his successor, Governor Buddy McKay, also agreed on the appointment of Quince. Justice Quince became the 3rd female and first African-American woman to head any branch of Florida government when she became the Chief Justice of the Florida Supreme Court in 2008. With a judicial career spanning over 25 years, Justice Quince retired from the Florida Supreme Court on January 7th, 2019. After serving the 21 million Floridians in both the Attorney General's office and the judiciary, Justice Quince looks forward to more time with her family, friends, and causes that are near to her heart. She has started the next chapter with a 25-country world cruise in January 2019. After returning from her cruise, she began volunteering on an independent review panel that evaluates cases where there have been an allegation of wrongful conviction. In addition, she is a member of the board of the Florida Bar Foundation. Justice Peggy Quince is a member of the Gamma Theta Omega chapter of Alpha Kappa Alpha sorority and a member of the Lynx Incorporated. For her commitment and service to the law and community, she has received numerous honors and awards, including but not limited to induction into the National Bar Association Hall of Fame, Stetson University College of Law Hall of Fame. She was named the NBA Women Lawyers Division Jurist of the Year and was named an ABA Margaret Brent Woman Lawyer of Achievement. Justice Quince also received the Lifetime Achievement Award from the Florida Bar Government Lawyers Section. It's exhausting. I'm so glad you are here to join us this morning. We have asked Justice Quince to speak about what she has seen in her illustrious career in terms of changes in the court, and also to make observations about some of the current events in Florida. And with that, Justice Quince, we are honored to have you. Thank you.
And thank you. I want to thank the leadership and all the members of the Volusia County chapter of the League of Women Voters for inviting me to be a part of your program. And I am always pleased to talk with League members because I know that you are concerned about voting and democracy in this country, and that you are interested in issues involving government and history and civics. And so it's always a pleasure to talk with people who want to know more and understand our system of government. And so today I'm going to talk to you a little about the judicial branch of our government, our court system, and how it relates to some of the issues that are presently on our minds, some of the issues that we see and have seen coming out of our Florida legislature. You know, whenever we take surveys to see what the American people know about government and civics, the branch of government what branch of government do you think they know the least about? And if you said it's the judicial branch, you would be correct. That is the least known branch of our government. And it's often said that the judicial branch is really the weakest branch of government. And that's because, unlike the legislature, the judicial branch does not have the power of the purse. And unlike the executive branch, the judicial branch does not have the power of the army. But I would submit to you that the judicial branch has a very important power, and that is the power of the pen. And that pen can, under the right circumstances, declare acts of the legislature unconstitutional. It can declare executive orders unconstitutional. So I kind of take issue with the statement that they're the weakest branch. But one of the things that you have to understand is that the courts are indeed limited in the sense that a case has to be brought to the court for it to take any kind of action. A court cannot just simply read a statute and say, legislature, this act is unconstitutional. You have to have a party who's adversely affected by the law and believes the law to be unconstitutional in whole or as it applies to that particular individual. They must file an action in the court to have the court take a look at it and make a determination on whatever issues are involved. So as you heard in that bio that Mary gave, I have spent the bulk of my legal career really as a government lawyer in some form. Because of the 46 years I practiced law before my retirement, I was in the private sector only for about 4 years, having spent 13 and a half years with the Attorney General's office and 25 years as a part of the judiciary. But the years I spent in the Attorney General's office really, in that capacity, I really had the opportunity to learn about the multiple layers of our court system. Not only did I learn about them, but I participated in the various levels. For example, in the trial courts, I conducted evidentiary hearings and often assisted attorneys with the state attorney's office in having evidentiary hearings before our trial courts. And then I would have hearings in our federal district courts, and then appeals at the federal level, and the state appellate and Florida Supreme Court and United States Supreme Court level. So from these experiences, I've learned a lot about the working of our court system. And my experience in the Attorney General's office, of course, led me, I think, it held me in good stead in becoming first an appellate court judge and then a justice on the Supreme Court. And at the Supreme Court, I got really a bird's eye view of the interplay of the legislative branch of government and the executive branch of government with the judicial branch of government. And as I said earlier, in the final analysis, any bill or executive order that was unconstitutional could, in fact, have been declared so by the Florida Supreme Court if a party brought it before the court. During my 20-year tenure on the Florida court, I did, in fact, have an opportunity to see a lot of controversial issues come before the court. A lot of legislation that was challenged, even executive orders by the governor that was challenged. And I'm sure most of you remember the controversial election in 2000. Well, I was on the court during the time of the Bush versus Gore situation. And we finally called it at the court our 36 days of pre-Christmas festivities, because that's how long our court system dealt with the 2000 election. There were multiple cases that were filed in both the trial courts and in the Florida Supreme Court. We actually, at the Supreme Court level, had two full-blown opinions that came out of that court. And of course, the last of those two opinions was eventually overturned by the United States Supreme Court, which is another issue in my mind in and of itself. But I also dealt with cases involving the parental consent for abortion and whether or not that particular statute was constitutional. We at the court dealt with many times the last redistricting effort by the court, and there was litigation that covered from 2012, it covered like a 3 or 4 year period. Our court actually issued 8 opinions or orders in that redistricting situation. So as you can see, lots of issues that involve all of us and our lives on a daily basis come before the court system. We saw multiple challenges to the state's death penalty laws. And even the school vouchers came before the court at one point. We saw, I know you remember the well-publicized case involving the right to die out of Pinellas County concerning Terry Schiavo. And at one point, that case also came before the Florida Supreme Court. Now, I tell you this so that you understand that there are multiple aspects of our lives that come before the court system. And while we may not be directly, or you may not be directly affected by it at the time it comes to the court, it could have ramifications for your life at some point. But I tell you, in all honesty, that the courts have seemed to go through a change since the time I first became a judge. I was appointed to the Second District Court of Appeal and the Florida Supreme Court at a time when the judicial nominating process, because as you know, our appellate court judges and our Supreme Court justices go through a judicial nominating process. Well, that process has changed since the time I went through the process. The persons who are interested in being on our appellate courts or being on our Supreme Court fill out a very lengthy, comprehensive application. They send in writing samples. They have people who are their, I guess you call them, that recommend them, those kinds of things. All of that is sent to a judicial nominating commission. And back in the 90s, when I went through that process, the nominating commissions were composed of 9 people. 3 of the persons on that commission were appointed by the governor. 3 of the persons on that commission were appointed by the bar. And then those 6 people got together and chose 3 additional people. So no one person or entity controlled who was on the nominating commission. Now, however, the governor essentially appoints all of the members of the commission. He directly appoints 5 of those members, and the bar then sends the governor a list of names, and the governor appoints 4 of those people. So essentially, the governor appoints all 9 members of the Judicial Nominating Commission. In addition to the governor appointing all the members of the commission, there now appears to be a litmus test for appointment to our courts at all levels. Over the past 20 plus years, more and more appointments to both the state and federal courts have been persons who belong to or have belonged to the Federalist Society. Why is this important? And I don't want you to take my word for why it is important. I would ask that each of you Google the Federalist Society and see for yourselves exactly what this means. But I'll try to briefly tell you what I understand about the Federalist Society and the judicial philosophy of the members of that group. Now, we start off with, this is a conservative group of lawyers and judges and law professors, and they believe that the Constitution should be interpreted in a textual and originalist manner. And what this means in a nutshell is that the Constitution should be looked at, and the terms of the Constitution should be, and the meaning given to the words of the Constitution should be given the meaning that it had at the time that the Constitution was drafted and ratified. More specifically, they say, they argue that the Constitution means no more and no less than what it meant to those who originally wrote and ratified it. And this is in direct opposition to what others argue is that the Constitution is a living, breathing document, and the text has to be interpreted in light of current times and current culture and society. My question to you, and a food for thought for you, is having the amendment process. We have a process for amending that Constitution. And doesn't that indicate that even the drafters intended the Constitution to be fluid and to keep up with the times? That is a question I think we all need to ask ourselves. So when we look at the United States Supreme Court, we see that 6 of the 9 members, 9 justices on that court, are or have been members of the Federalist Society. Brett Kavanaugh, Neil Gorsuch, Clarence Thomas, John Roberts, Samuel Alito, and Amy Coney Barrett, the newest member of the court. And when you look at the bios and resumes, a large number of the other federal court appointments that were made by the last administration are members or former members of the Federalist Society. But it really doesn't stop there. If you look at the Florida Supreme Court and other judges appointed by the last at least 2 governors of this state, and you will see a large number are present or former members of the Federalist Society. It has been said, and these are not my words, but it has been said that the Federalist Society has diligently and deliberately shifted the judiciary of this country to the right. And so there are many people who say that progressive and liberal ideas will not find favor in our courts today, in many of our courts today. But cases involving what seems to be unconstitutional laws will nonetheless have to be taken to the courts for resolution. As you know, the governor signed into law just this past Monday, the 19th, House Bill 1. This was the bill that we, the members of the League, and many other groups argued was an unconstitutional attempt to stifle our right to protest and assemble, and our right to speak and have our voices heard. It was signed into law on Monday. A lawsuit has already been filed in the United States District Court for the Middle District of Florida, Orlando Division. And the lawsuit was filed by the Lawyers Matter Task Force. I'm not familiar with that group, but they have alleged a number of constitutional violations, and they have alleged that HB 1, or I should say the law, first violates the First Amendment rights to speech and assembly, the same arguments that we made in many of the committees. It violates the Eighth Amendment prohibition against excessive bail, fines, and cruel or unusual punishment. And they additionally allege that the law violates the 14th Amendment due process clause because it does not specify and lay out what conduct constitutes committing a riot. So those are the allegations that have been made in this complaint. I did a brief reading of it, so there might be other allegations in the complaint, but I do know that they have asked for injunctive relief, and that is to stop the enforcement of the law until such time as the court has had an opportunity to look at it and determine its constitutionality. And they allege that they are harmed because it's an interference with peaceful conduct that they had planned for today, April the 24th. So these allegations might not be all that is in the lawsuit, but it's what I've gleaned from just a cursory looking at the lawsuit. So HB 1 is now state law, and these issues that we tried to bring to the attention of the legislature is now being litigated, and is probably not the last lawsuit that will be filed concerning that particular law. Right now, the legislature is poised to pass some voter restriction laws. I believe that Senate Bill 90 and House Bill 7041 are making unnecessary changes to our voter laws with either the intent or the consequence of making it more difficult to exercise our right to vote. And why are we making these changes? The 2020 election in Florida, as you know, was unprecedented. There were no real problems. The voter turnout was higher than it had been in decades, at almost 77%. And we had a record number of people using our vote by mail ballots and using drop boxes. And of course, you know that a lot of the vote by mail and drop box and mail usage was because of the pandemic that we are now still in, and because people had lost some faith in our postal system. But now the legislature is going to, I believe, in some respect, restrict the use of both the vote by mail ballots and the drop boxes. And the reason I said in some respects, because these bills are very fluid. And just yesterday or the day before, there were some small amendments made to these bills. And so we don't know what the final version is going to look like, but we do know that it is going to restrict who can request and turn in mail-in ballots for people. There was a time when my neighbor didn't feel like driving or couldn't for some reason drive. I could take her ballot at the same time I took mine. As long as it was signed, it was okay, it was turned in. I can no longer do that. You'd have to be someone's immediate family member or their legal guardian. I believe they're trying to amend it to allow people from the supervisor of elections office to go to nursing homes and things like that to get ballots. But the version that I read did not have anything in it that would help people who did not have some family member or legal guardian to assist them. And there are changes in the kinds of ID you can use to register online, or change your name, or change your party affiliation. The ID is limited to your driver's license number, your Florida ID number, the last 4 digits of your social security number. So there are changes in the works that I would submit to you are truly not necessary. There's been no demonstration that there was fraud in our election. So why do we need these changes? And I know that there is going to be litigation about these changes. I also suspect that there is going to be a litigation filed concerning Senate Bill 1890 and House Bill 666. Although, as I understand it, just yesterday, the House accepted the Senate version, 1890. And so that is going to be the version that's going to be voted on by both the Senate and the House. But these are attacks. That bill is an attack on the citizens' initiative process and would make it much more difficult. And what that bill does, it limits individual and organizational contributions to the signature gathering stage of the initiative process to $3,000. This is at the expensive stage of the citizens initiative process. And I'm going to just give you an example to show you just how expensive it is. On this last Thursday, Thursday was the 22nd, the Florida Supreme Court, in a 5-2 decision, said that a citizens initiative that would have allowed recreational use of marijuana in Florida, the Florida Supreme Court in that decision said it could not go on the ballot because the use of the language permits in the ballot summary was misleading. Now, that was taken issue with by the people in the dissent, but nonetheless, it was a 5-2 decision. But what was really interesting in the report about that Supreme Court case is that it said that the proponents of that amendment needed to gather 900,000 signatures. Now, that is 8% of the voters from the last general election. And generally, you try to get more than that 900,000 because the Secretary of State's office vets those signatures and throws some out for various and sundry reasons. The people who were supporting that amendment raised $8 million to help gather these signatures. $8 million. And if they want to start over, now that the Supreme Court has said that the version they have cannot go on the ballot, they're going to have to start gathering new signatures. They can't use those same signatures. The signature gathering process is very expensive. And if you limit contributions to $3,000 a person or $3,000 a company or an entity, this takes a lot of $3,000 to raise $8 million. Ironically, once that signature gathering process is over and the Secretary of State has vetted all the signatures, that $3,000 limit is no longer applicable. So if you want to oppose that amendment, that proposed amendment, you can get unlimited funds to do so. So opponents could then raise a lot of money in very large chunks and not worry about that $3,000 limit. I believe this is yet another piece of legislation, should it become law, is going to be vetted in our court system. In the initiative vein also, there are bills or a joint resolution that would increase the percentage for passing a proposed constitutional amendment. You know, presently it's 60%. When I first moved to Florida, it was 50%. Now they want to change it to 66 2/3%. Well, that has to be voted on by the electorate. And so if that joint resolution passed, you would see it on the ballot in 2022. And this, I tell you this just so you see in context the attack on the citizens initiative process. But should that 66 2/3% pass, there wouldn't really be any litigation because the voters would have okayed it. The voters would have said, yes, we want 66 2/3. But if you look back on those amendments that have passed citizens initiatives, very few, I can't think of one right off, were passed by 66 2/3%. I know that the Fair Districts Amendment did not pass by that percentage. I don't believe the medical marijuana one passed by that percentage, but I'm not sure about the returning citizens. I can't remember the numbers involved in that one. But in any situation, in any legislation that may potentially be litigated, those who want to bring a challenge to the law have to consider certain issues. One is who would be the right people to bring it, and what are the issues that you want the court to address. Now, in order to bring a lawsuit, the named plaintiffs, the named people who are bringing the suit must have standing to challenge it. And this is a legal requirement that says a person cannot challenge the constitution of a law unless that person can demonstrate that he or she is or will imminently be harmed by the law. And generally that harm cannot be the same harm shared by the community at large. Although there are some exceptions in the First Amendment context, which is the context that one of the allegations made about the anti-protest law that we have, there are some circumstances where you can in fact bring the suit, although you're not immediately harmed by it. So you stay tuned. There are going to be lawsuits brought. Groups are in the process of looking at who would be the best plaintiffs for these lawsuits and what would be the best issues that can be brought. So I would submit to you that once the election bills become law, you will see some filings in the court. And should the bill concerning the $3,000 limit become law, again, you will see some litigation filed. And finally, there's an area that's brewing that I know will generate court involvement, and that is in the area of redistricting. As you know, every 10 years after the census, we have a determination if your state gets new or even reduced seats in the legislature or in Congress. And so we're at that stage. As far as we know, the actual redistricting process here in the state of Florida has not begun. We don't have the census information. We don't have the apportionment data from the federal government yet. But, and I stress, this is just rumors. There are rumors that Florida will be getting 2 additional congressional seats. And if that's true, we're going to really have some changes that have to be made in our districts. So look out for that. It's on the horizon. And we know that in 2010, when we passed the Fair Districts Amendment, there were some requirements that our legislature has to look at in order to do fair redistricting. The districts have to be drawn so that they do not favor or disfavor any political party or an incumbent. The districts should be drawn with, not drawn with the intent or the result of denying or abridging the opportunity for racial or language minorities to elect representatives of their choice. The districts need to be contiguous. The districts should be as nearly equal in population as possible. The districts should be compact, and the districts should use existing political and geographic boundaries where feasible. So those are some of the principles that our legislature has to follow when doing redistricting. And we know that during the last redistricting, which started in 2012, the Florida legislature did not follow those principles in drawing some of the new maps. And what followed was 4 years of litigation with about 8 opinions and orders coming out of the Florida Supreme Court. And ultimately, the court had to throw out a legislative map and accepted maps that were drawn by the League and the Fair Districts Coalition. That was several years of litigation to get our redistricting straight. We expect that we're going to have to do some litigation on that when the redistricting starts next year. So stay tuned and keep your eyes open for when the legislature will start that process. And with that, I have been talking here for quite a long time. And so with that, I'm going to stop and entertain some questions. If I don't know the answer, I will get back to the Volusia County League leadership with whatever information I can find. But at this point, I am going to turn the program back over to Marianne.
Thank you.
Okay.
Thank you so much. Absolutely fascinating. You did, in fact, touch on a number of the questions our members have. I'm going to start with some of the things in that have come up in the chat room.
Okay.
Thoughts on what we can anticipate in terms of capital punishment? Do you think that that will be challenged in Florida?
Well, things have changed so much since I was on the court. As you know, back a couple of years ago, the majority on the court said that you had to have a unanimous recommendation of death in order to receive a death sentence. Well, I believe that has changed now, and there's been a step backwards in that process. And although there were a number of people whose sentences were overturned, there are still others who are now caught with the change that the court has made and are still going through the process. And so, yes, I believe that there will be additional challenges to Florida's death penalty laws.
Okay. I guess this is more of a federal issue. Any thoughts on the future of Guantanamo as a prison? Do you think we'll see the end of that?
I must confess that I have not focused on that particular issue. What's going on in this state and around the country with all the new, what I consider to be voter suppression laws and the laws trying to stifle our right to assemble, that I have not really focused on that particular issue. So I really cannot answer that question.
No problem. Thoughts about expanding the U.S. Supreme Court? Oops.
Well, there has been torn about it. I see, as you heard what I said earlier about the makeup of the court, I would like to see people who don't follow any particular ideology appointed to the court. But,
Oh, dear.
at 9 is a lot. Are we still on?
All right, you're unfrozen now. Yes.
Okay. Did you hear what I said at the end, which is that
I just heard 9 is a lot.
I haven't really made up my mind on that. Yes.
Okay. Okay.
And I haven't made up my mind on that issue.
Will the proposed federal voting rights legislation supersede state laws?
It certainly will, as far as federal elections are concerned. And then you have to understand that for the most part, our general elections are federal elections because we have every 2 years on our ballots, Congress people, senators, and of course, presidential election year, there's the president. And so for the most part, our elections would be governed by it. If you look at a municipal election, and would not supersede in that kind of election.
Got it. Okay. Oops. Okay. You mentioned the changes in the process for appointing members to the Florida Supreme Court.
Mm-hmm.
Is that an issue where there could be a ballot initiative that would establish a process?
It certainly could. It certainly could be. I mean, the citizens have a right to do and have as a part of the Constitution whatever they feel is appropriate. sometimes we don't do what is appropriate. I look back, I must say, one of the first initiatives I ever saw as a Supreme Court justice, because, we look at these initiatives to make sure that they are a single subject, that the ballot title and summary are not misleading. And one of the first ones I ever saw was the pregnant amendment.
Mhm.
It met the criteria and it was passed. Now, whether I liked it or not wasn't the issue, and I didn't like it. I didn't think it was appropriate for our Constitution, but the people did. So as you can see, the people have the right to put things in the Constitution, and that could be an appropriate subject if you can raise the money.
There we go. In the world of Citizens United, I'm amazed that a $3,000 limit could even.
And that's probably going to be one of the bases for the litigation.
I would hope so. Let's see. Here's an interesting one. Are there any restrictions on you running for elected office, should you so decide?
There are no running for office takes a lot of energy, a lot of time, and a lot of money.
All of the above.
Yes.
All of the above. So, well, thank you so much for your service, for your involvement, continuing, and for joining us this morning. It's been fascinating, and we have certainly enjoyed the pleasure of your comments. Thank you.
And I hope that I did those things that you were interested in, because, our court system is going to be involved in all of this. And to what extent and which court you take it to, whether it be state or federal, we're going to have to be very careful about the issues and the people that we have as our plaintiffs.
Good
Judge
thought.
Quince, this is Nikki Junkins. I just want to thank you for such a knowledgeable, thorough, and insightful discussion of the courts. I think it reinforces our need to be very vigilant in what's happening, so that when it is bringing people's voices before the courts. Okay. So thank you so much. And I'm going to ask those on the line to give you a virtual round